Something is happening right now inside the United States Supreme Court that every gun owner, every gun control advocate, and frankly, every American citizen needs to understand, and most of them have absolutely no idea it is coming. I am not talking about a bill sitting in Congress. I am not talking about a proposed regulation from some federal agency. I am talking about a collision course that has been building since 2008, accelerating through 2022, and is right now, in the summer of 2026, reaching a breaking point that will redefine what constitutional rights actually mean in this country. Here is what we know. The Supreme Court currently has multiple Second Amendment cases either decided, pending, or positioned for review, including National Association for Gun Rights versus Lamont, which was distributed for conference on May 21st of this year. That is 4 days ago. Wolford versus Lopez had oral arguments in January. Duncan versus Bonta and Viramontes versus Cook County are circling. The entire architecture of gun permitting across 43 states is sitting inside a legal pressure cooker, and the temperature is rising every single week. If you have a carry permit, if you have been denied one, if you live in California, New York, Massachusetts, Illinois, or any northeastern state that built its identity around gun regulation, what happens in the next 6 to 18 months will directly affect your life in ways that cable news is not explaining clearly. This channel exists to give you the analysis before the headlines catch up. Subscribe right now. Turn on notifications. Because when these decisions land, you need to understand them within hours, not days. Let us get into exactly what is building and why every state should genuinely be paying attention. To understand why 2026 is the year everything converges, you need to understand how we got here. Because this did not happen overnight. This is the result of a legal strategy that has been executing methodically, patiently, case by case for nearly 2 decades. Start with 2008, District of Columbia versus Heller. For the first time in American history, the Supreme Court said explicitly, the Second Amendment protects an individual right to keep and bear arms unconnected to service in a militia. That sounds obvious now. It was not obvious then. For decades, the dominant legal interpretation held that the Second Amendment was about collective militia service, not personal ownership. Heller demolished that interpretation completely. But here is what most people miss about Heller. It opened the door, but it left enormous ambiguity about what could walk through it. Justice Scalia's majority opinion explicitly said certain regulations remain permissible. Permit systems, licensing requirements. The court declined to define the full boundaries. That ambiguity became the battlefield for the next 14 years. 2010, McDonald versus Chicago. The court incorporated the Second Amendment against the states, meaning states and cities could no longer simply ignore Heller. The right applied everywhere. Chicago's handgun ban fell, but again permit systems survived. Waiting periods survived. The right existed in theory, while the practical machinery of restriction remained largely intact. Then 2022 changed everything. New York State Rifle and Pistol Association versus Bruen. This was not just another gun case. This was a procedural revolution. Justice Thomas, writing for a 6-3 majority, threw out the framework that lower courts had used for 14 years, a balancing test weighing government interest against individual rights. Replaced it with something far more demanding, the historical tradition test. Any gun regulation must now be grounded in analogous laws from 1791 or 1868, not modern policy rationale, not public safety data. History. Do you see what that standard actually does? It asks one devastatingly simple question. Did governments in 1791 require citizens to obtain permission before exercising this right? The historical record has an answer, and that answer is precisely why 2026 feels like the edge of something enormous. This is where I need you to lean in, because what I am about to walk you through is the actual legal landscape as it exists right now, not speculation, not fear-mongering, but 4 specific cases moving through the system simultaneously that collectively represent the most significant pressure on American gun law since Bruen itself. Let us start with Wolford versus Lopez, Hawaii. after Bruen struck down discretionary permitting in 2022, did something remarkable. Rather than simply comply, the state legislature convened and passed a new law with a provision so unusual that Supreme Court justices gave it a nickname during oral arguments in January of this year. They called it the vampire rule. Here is how it works. Even if you have a valid carry permit, you cannot bring a firearm onto any private property open to the public restaurants, parks, banks, parking lots, unless the property owner has explicitly and affirmatively given you permission. No sign saying you are welcome, no assumed consent, you must be invited, like a vampire crossing a threshold. The Ninth Circuit upheld this law. The Second Circuit struck down an identical provision in New York. Two federal appeals courts, directly contradicting each other on the same constitutional question. That split is precisely why the Supreme Court accepted the case. The question they will answer determines what percentage of American soil, privately owned but publicly accessible land, becomes effectively off-limits to lawful carry. We are talking about the majority of the places you actually go every single day. Now move to Duncan versus Bonta and Viramontes versus Cook County. California prohibits magazines holding more than 10 rounds. Illinois broadly restricts what it classifies as assault weapons. Both laws are being challenged under the Bruen historical tradition standard. Both cases were circling conference at the Supreme Court in February of this year. The constitutional question is elegant in its simplicity and staggering in its implications. In 1791, did any government in America limit how many rounds a citizen could load into a firearm? Historians and legal scholars have searched extensively. The analogous historical regulation essentially does not exist. If the court applies Bruen consistently, that absence of historical precedent becomes a constitutional death sentence for magazine capacity limits and semi-automatic weapon bans across multiple states. Approximately 24 million AR-style rifles are currently in civilian hands in America. The legal status of every single one of them in states like California and Illinois is part of what hangs in the balance here. Now I want to talk about the case that may ultimately be the most consequential of all. National Association for Gun Rights versus Lamont, Connecticut. This case was distributed for conference on May 21st of this year, 4 days before I am recording this. This is the case that comes closest to the sweeping scenario. You may have seen other channels describe a ruling that strikes at permit systems as a category rather than attacking individual provisions one at a time. The National Association for Gun Rights is arguing that Connecticut's permitting framework violates the Second Amendment at a structural level, not this specific rule, the entire permission-based model. If the court grants certiorari, if they agree to hear it, you will be looking at oral arguments in the 2026 to 2027 term with a potential ruling that reshapes the legal foundation of gun permitting nationally. That has not happened yet. Certiorari has not been granted. But the case is live, it is current, and the conference date was this month. And then there is the battle that almost nobody is covering, California's ammunition background check law. This is the second front in a war that most analysts are missing entirely. California requires a background check not just to buy a firearm, but to purchase ammunition. In July of 2025, a 3-judge Ninth Circuit panel struck that law down as unconstitutional under Bruen. California immediately petitioned for en banc review. The full Ninth Circuit agreed to rehear it, scheduling arguments for March of 2026. In January of this year, the Department of Justice and a coalition of 25 states filed amicus briefs arguing that the ammunition restrictions violate the Second Amendment. Think about the strategic logic here. If you cannot restrict the firearm itself, you restrict what makes the firearm function. If the courts close that avenue too, the entire indirect restriction playbook starts collapsing. That is why this case matters as much as the headline cases, maybe more, because it reveals the direction that heavily regulated states are moving when the primary route gets blocked. 4 cases, multiple fronts, all converging inside the same 12 to 18-month window. This is not a wave approaching. This is the wave, and it is already breaking. Here is where I want to be completely straight with you. And I mean that seriously, because I think you deserve analysis that actually respects your intelligence. Some channels will tell you that the Supreme Court has already issued a sweeping ruling eliminating every permit system in America. That is not accurate as of today, May 26, 2026. What is accurate is that the legal architecture supporting those permit systems is under sustained, serious, and increasingly successful challenge. Those are meaningfully different statements. One is a fact about the present, the other is a prediction about the direction of travel. I deal in the first category, and I will clearly label anything in the second. So let me give you 3 scenarios grounded in actual legal reasoning about where this goes from here. Scenario 1 is what I call the incremental path, and it is the most historically consistent with how the Supreme Court actually operates. The court continues issuing targeted rulings, each one striking a specific type of restriction using the Bruen historical standard. No single earthquake. Instead, a series of smaller tremors that cumulatively dismantle the permitting architecture piece by piece. Magazine limits fall, certain waiting periods fall, ammunition restrictions fall. By 2029 or 2030, the practical effect in heavily regulated states looks nearly identical to a sweeping ruling, but it arrived through a decade of litigation rather than a single decision. This path is already underway right now. Scenario 2 is the moderate path, where the court accepts NAGR versus Lamont and issues a ruling that is significant but deliberately narrow in scope. It addresses Connecticut's specific framework, establishes clear precedent on what permission-based systems can and cannot do constitutionally, but explicitly leaves room for states to construct alternative compliance mechanisms. This gives gun rights organizations a powerful new tool while giving regulated states a runway to adapt. Expect years of follow-on litigation as every state tests the boundaries of whatever line the court draws. Scenario 3 is the broad ruling, the version other channels present as already having happened. A sweeping decision that strikes permit systems as a constitutional category, applying immediately and nationally. I want to be honest with you. Legal scholars across the ideological spectrum consider this the least likely path, not because the constitutional argument is weak, but because the current court has consistently preferred surgical precision over broad strokes. It is possible. It is not probable in the immediate term. Now, I need to give you the other side of this, and I mean the real other side, not a straw man version designed to be easily dismissed. The historical tradition test that Bruen established has drawn serious, substantive criticism from constitutional law scholars who are not simply gun control advocates. Their core argument has genuine intellectual weight. The framers of the Constitution could not have conceived of a 30-round magazine, a semi-automatic rifle, or the specific lethality of modern firearms technology. Applying 1791 standards to 2026 weapons, they argue, is methodologically equivalent to evaluating internet speech regulations using only the precedents available when the founders were operating hand-operated printing presses. The right scales with the technology. Why should the regulation not scale similarly? The empirical dimension matters here too. States with stricter gun laws average approximately 5.93 firearm homicides per 100,000 residents, according to recent data. The relationship between permit systems and violence reduction is genuinely contested in the research, but the research is not empty. Suicide, which drives a significant portion of overall gun death statistics, shows clearer correlations with access restriction than homicide does. Anyone who tells you this question has an obvious answer on either side is selling you something. The constitutional question and the public safety question are both legitimately difficult. Holding both of those truths simultaneously is not weakness. It is the beginning of actually understanding what is at stake. If you want to understand what comes next, stop looking at the Supreme Court for a moment. Start looking at the state capitals. Because the real story of the next 18 months is not just what the court decides. It is what happens in the hours, days, and weeks after those decisions land inside the offices of governors and attorneys general who have spent decades building regulatory frameworks they have absolutely no intention of surrendering without a fight. We already have a case study, and it is instructive. Bruen came down in June of 2022. Within 2 weeks, not months, Governor Hochul of New York convened an extraordinary legislative session. By July 1st, she had signed the Concealed Carry Improvement Act into law. Read that timeline carefully. The Supreme Court struck down one system on a Thursday. New York had a replacement system signed into law before the month was over. The new law removed the proper cause requirement that Bruen specifically invalidated, but it simultaneously added more than 30 new sensitive location designations where carry is prohibited, mandatory training requirements, a character reference process, and remarkably, a provision requiring applicants to submit their social media account information for review. The message from Albany was unambiguous. You won this round. We are not done. That law has itself been challenged. Portions have been struck down. The litigation is ongoing right now, but the strategic playbook is visible for anyone paying attention. Here is what that playbook looks like when states deploy it going forward. Watch for these specific mechanisms in your state legislature. Ammunition licensing is already being litigated in California, as we discussed. Safe storage mandates with government inspection provisions are being drafted in Massachusetts and other northeastern states. Excise taxes on firearms and ammunition. Some proposals reaching 11% are moving through committees in multiple states, operating on the theory that taxing a right is constitutionally distinct from restricting it, a theory that will absolutely be tested in court. Owner verification systems, deliberately not called permit systems, are being modeled in Connecticut, the same state currently at the center of NAGR versus Lamont. Liability insurance mandates, requiring gun owners to carry civil liability coverage, are being proposed as consumer protection measures rather than gun regulations. Every single one of these mechanisms is designed to pass a threshold legal test while achieving the same practical effect as the permit systems being challenged, and every single one of them will face litigation the moment they are enacted. Here is the question I want you to sit with. If the court keeps striking down each new mechanism as it appears, and states keep innovating new mechanisms in response, where does that cycle end? And who absorbs the cost of fighting it on both sides in the meantime? That answer matters more than any single court ruling. Let me stop talking about institutions for a moment and talk about you specifically. Because everything I have walked you through, the cases, the historical tests, the state counter strategies, it all eventually lands on one person, a real person, in a real state, making real decisions about how to navigate a legal landscape that is shifting faster than official guidance can keep up with. Where you live right now determines your immediate reality more than any Supreme Court decision does. If you are in one of the 25 states that already operate under constitutional carry, Texas, Florida, Tennessee, Montana, and others, your day-to-day situation is legally the most stable it has ever been. Bruen actually strengthened the constitutional foundation under your existing rights. Your practical concern is not restriction. It is understanding that driving across a state line can change your legal status completely and immediately. Know exactly where your rights end geographically before you travel with a firearm. If you are in California, New York, Illinois, Massachusetts, New Jersey, Connecticut, Maryland, or Hawaii, your situation is the most dynamic and the most consequential to monitor closely. The laws you are currently operating under are actively being challenged in federal courts right now. Nothing changes for you today. But 18 months from now, the compliance requirements in your state could look meaningfully different. Stay current. Do not rely on what you knew 2 years ago. Regardless of which state you are in, there are 3 things that apply universally right now. First, federal prohibitions on firearm possession have not changed and will not change regardless of what SCOTUS does with permitting. If you are a prohibited person under federal law, none of these rulings affect you in the direction you might hope. Second, document everything. Background check approvals, purchase receipts, training certificates. When laws are in transition, paper trails protect you. Third, sensitive place restrictions are the most consistently upheld category of gun regulation across every court and every legal standard. Schools, federal buildings, courthouses. Do not test those boundaries regardless of what you believe your broader carry rights are. The law is moving. Move carefully with it. Let me tell you exactly what we know and exactly what we do not know, because that distinction is the entire difference between informed analysis and noise. What we know with certainty is this. The The Supreme Court has fundamentally restructured how gun regulations are evaluated in America. The historical tradition standard established by Bruen is real, it is active, and it is being applied right now in federal courts across the country. Multiple cases, Wolford versus Lopez, Duncan versus Bonta, Viramontes versus Cook County, National Association for Gun Rights versus Lamont, are either awaiting decision or positioned for review within the next 12 months. The states most affected by this legal pressure are not standing still. They are building new regulatory frameworks in real time, and those frameworks will generate new litigation immediately upon enactment. What we do not know is how broadly the court will rule, how quickly those rulings will arrive, and whether the political composition of the court changes before the most consequential decisions land. That uncertainty is not a reason to disengage. It is the reason to stay exactly as informed as you are right now. Here is my commitment to you. When NAGR versus Lamont gets a certiorari decision, I will have a full breakdown within 24 hours. When Wolford versus Lopez comes down, same thing. No spin, no agenda, just the actual text of what the court said and what it means for your specific situation. Subscribe. Turn on every notification this platform offers. The next ruling could drop any morning you wake up. You want to understand it before your elected officials have had a chance to tell you what to think about it. I will see you the moment it happens.